Good afternoon again. I'm Amy Murphy. I'm a litigator at Miller Johnson. I'm one of the chairs of the Young Lawyers Division of the FBA chapter here in West Michigan. Thank you for joining us. The FBA is sponsoring this program today with the hope that we can increase participation in the federal court's pro bono program for prisoner civil rights cases. And I think you're going to hear today from our panelists at least a couple of things. That these cases are great opportunities to get up on your feet and try a case to a federal jury, that they don't require deep background in Section 1983 or other civil rights law, and that you will enjoy this opportunity and get some memorable stories out of it. And then just before we get started, I'll make a quick plug. The FBA has another program coming up on May 11th. It's Social Media as Evidence. And it's going to be a really interesting program. We've never done this before. We're inviting Chris Madsen, who's an attorney with, formerly with the Department of Justice, and more relevant to this probably, formerly the Associate General Counsel and Head of Global Law Enforcement, Safety and Security for Yahoo. And he's going to be able to talk with us about his experience working with tech companies in responding to subpoenas and search warrants. So please mark your calendars for May 11th at noon. Without further ado, let me introduce the panel. We have with us first Magistrate Judge Ray Kent. Judge Kent has taken charge of the federal court's prisoner civil rights program. He is the keeper of the list of pro bono attorneys. So I'll warn you now that he may be calling you as early as this week to see whether you're available to help out with the case. And he will talk with us today about why these cases need pro bono attorneys and how the program works, and we'll get to that soon. We also have with us two attorneys from the Michigan Attorney General's office. Both are in the section handling these cases for the Michigan Department of Corrections. We have Michael Dean and Sarah Robbins. And then we have two attorneys who have taken on these cases pro bono. We have LaRissa Hollingsworth, who's here. She's a litigator at Drew, Cooper, and Andine here in Grand Rapids. And my colleague, Andy Portinga, is also here. He's a litigator at Miller Johnson. Before we get started, Sarah, I know you want to make one comment about your participation and Mr. Dean's participation in the program.
Thanks, Amy. As Amy said, Mike and I work for the Department of Attorney General. We're in what's called the MDOC Division. I just have to make a disclaimer that anything we say today is from our personal capacity as defense attorneys on behalf of the state, and we're not officially discussing any policy or speaking on behalf of the Attorney General. Thank you.
Thank you, Sarah.
Wait a minute. It's not anything you say today can and will be used against you in court later?
I won't go that far, Judge, but not at least attributed to the Attorney General anyways.
Okay.
Thank you to our panelists for sharing your experiences working on these cases. Judge Kent, I'm going to toss a softball to you. Please tell us about this program and why you think these cases benefit from having an attorney represent the plaintiff on a pro bono basis.
All right. Well, let me start by thanking all of you for joining and participating in this seminar. I'm not sure what we're calling it, but this meeting today. And for considering representing an indigent person, because all of these plaintiffs are indigent. It is hugely important that we provide representation to the indigent. It ensures access to justice for everyone. And by doing that, we further legitimize the rule of law in America, which is a bedrock principle of our democracy. And I think that none of us need to look much further back than the events of the last 5 or 6 months to know that that remains as important today as it was in 1776. So I appreciate you participating. I've spent much of my career representing the indigent, primarily in my role as a criminal defense lawyer, both privately and later as the federal public defender in the district. The plaintiffs in these cases are people that I know well, people that I've represented over 30-ish years of practice. And I think you'll find them to be, if you get involved in this program, people who are very interesting, who have life stories that are probably much different than yours, life stories that you can learn a lot from as a person and as a lawyer, and that the experience of knowing them will enrich your life in some meaningful way. And I think most people, I'll maybe let LaRissa and Andy touch upon this because they both handled these cases for the court in the past. But I'll let them touch on that. But I think, if you handle one of these cases, it will change you in important and good ways. So thank you. These cases, these prisoner civil rights cases, are the most common filed cases in United States District Court in the Western District of Michigan. Every year they make up roughly a third of our civil filings. So no other case comes even close in terms of raw numbers. The cases are almost always filed by the inmate himself or herself. Virtually all of them, as I said, are indigent. A rare case, and Sarah and Mike maybe could speak to this. I guess there are rare cases where you get a lawyer involved right out of the gate. Maybe a family has money or something and it can hire a lawyer, but it's rare. So most of these cases are filed by the inmates themselves. They're filed under Section 1983, which provides that an individual deprived of a right secured by the United States Constitution or a federal law by a person acting under color of state law can sue. So, these cases are mostly filed against Michigan Department of Correction employees. Sometimes we have contractors or doctors who are involved in healthcare of inmates who get named as defendants, but primarily it's MDOC employees who by definition are almost always acting under color of state law. As Sarah said, you don't really need a background in civil rights law. The issues are generally pretty simple. And Mike and Sarah, feel free to jump in and correct me if I'm wrong. But it seems to me that the vast majority of these cases allege either a violation of the First Amendment, and that comes in a couple forms. One is the First Amendment's protection of free speech. So the way that can be infringed in prison is, let's say an inmate and a guard have words about something, and the inmate files a grievance against the guard saying, hey, the guard told me, shut your mouth or I'll put you in the hole or something. And he's not supposed to do that under MDOC guidelines. Then the guard, the inmate often alleges, writes a ticket, a misconduct ticket against the inmate. And the inmate alleges it's pretextual. So look, I filed a grievance, which is protected conduct under the First Amendment and is allowed for under MDOC's own policies. In retaliation for me writing my lawful misconduct, this guard wrote me a ticket for, say, being in the wrong place at the wrong time in the prison, and maybe I lose some rights, benefits, or privileges that I would otherwise have. So First Amendment retaliation. Under the First Amendment, there are also religious claims brought of various types involving dietary restrictions, involving an inmate's ability to have religious, what do I call them, Mike? Like an inmate can have a cross and a Bible, and it's not, of course, just limited to Christians. So, a wide spectrum of religions are allowed to have icons that they need to practice their religion. So sometimes there's issues about that. The other category are claims under the Eighth Amendment for prison conditions cruel and unusual punishment. And, sometimes guards and inmates get in physical alterations in prison. And sometimes, inmates get injured. Sometimes guards get injured. Sometimes everybody gets injured. But that's one class of Eighth Amendment claim. And then there are other Eighth Amendment claims. Maybe an inmate will say, I'm not getting enough recreation time. I'm not getting enough time out in the yard or in the gym or whatever. And that's a cruel and unusual punishment. So I think those two are the categories. I don't think you need a big background in civil rights law, because the issues are pretty simple. More often than not, they come down to, two divergent stories. The plaintiff alleging one set of facts happened, the defendant's alleging a different set of facts. And, it often comes down then to the jury deciding who they believe. Before an inmate can file a claim, the Prison Litigation Reform Act requires that the inmate exhaust his or her administrative remedies. MDOC has adopted a three-step process, a grievance process, which an inmate has to follow and complete as a precondition to filing his or her lawsuit in federal court. One benefit of the process is it doesn't provide and create something of an administrative record, which can be of use to you and to the court once a lawsuit has been filed. So I think that's a kind of an overview of what the cases are. I know Amy provided me a few kind of general questions. And Amy, cut me off if I'm running over my time, okay? Because otherwise I'm liable to just keep on talking. So, the cases, when we appoint a lawyer on these cases, generally speaking, they are what we call trial ready, meaning discovery is closed. Typically, Sarah or Michael have filed a motion for summary judgment if they think it's appropriate, and the court has ruled on those. So when we call you and say, will you please take this case? The defendants, maybe some defendants have been dismissed. Oftentimes there are multiple defendants. Maybe some of them have been dismissed. Maybe some of the claims have been dismissed. And so the defendants and the claims will be well defined when we call you. Another question Amy posed was time commitment. I would say, and Mike and Sarah, again, correct me if I'm wrong, in my experience, most of these trials last, I would say 2 days is an average, including jury selection. So oftentimes you'll have jury selection on morning one. Plaintiff will offer evidence, that afternoon. Typically his or her testimony and maybe some witnesses, maybe some documents. Mike and I had a case with a plaintiff inmate who had a big stack of documents, and he handled them masterfully, I must say. I mean, he knew those documents inside out, front and back. But that's more, I would say, the exception than the rule. But plaintiff will offer evidence. Typically, Mike or Sarah will call, whatever MDOC employees are defendants. So if it's correctional officers or whoever, they'll testify. The case is typically to the jury the second day, often before lunch the second day, and the jury deliberates and you get a decision. So, on top of that, of course, you have trial prep time. And I think the old formula was, you spend an equal amount of time preparing for trial as trying a case. My experience has been that the young lawyers in these cases often spend a lot more time than that. And I probably would have too, because, if Amy is trying one of these cases, she wants to convince, Andy and the other partners at Miller Johnson that she is going to be the next F. Lee Bailey. And so, they tend to over prepare, which is fine and understandable. But I would say, minimum a week time commitment, probably. Andy, you think? You probably spend a lot more than that.
I think a lot. I think it is more, Your Honor, quite frankly.
Yeah.
But I mean, if you're going to take one of these on, you need to do it well, and to do it well, it takes time.
Yeah.
That being said, it's all a very valuable time, and it's a very good experience.
Yep, I agree 100%. And we'll hear more about that from LaRissa and from Andy. And I've probably talked enough, Amy. What do you think? Time to pass the ball?
I'll pass the baton on.
Okay.
I know, Michael, you have some thoughts about why these cases benefit from having a pro bono attorney involved. I also want, if you wouldn't mind, to hear what kind of 1983 background you think is necessary, because I think that is one hurdle that we face in convincing people that these are cases you can take on without that background.
Well, I was told to tell this story that I told yesterday. I came into the AG's office 13 years ago. It was a second career. I did law school at night for 4 years, and this was really my first job. So my first day, my boss is walking me around talking about 1983 cases, and she's dropping it in to conversation quite frequently. And my only thought during the entire conversation is, what happened in 1983 that was so important to prisoner litigation? And I'm so glad I did not raise my hand to ask the question, because they probably would have let me go on the spot. But I came to the office with zero experience in 1983 litigation. Frankly, the only training I had was my constitutional law 1 and 2 classes and in law school. And that certainly is not the type of background that you need for this. You really don't need much training other than to get familiar with the cases. And as Judge Kent said, the First Amendment retaliation cases are probably show up well over 60 or 70% of the cases. There's at least a retaliation claim usually. And then the Eighth Amendment, either excessive force claims or deliberate indifference claims. And the good thing about prisoner litigation is it really kind of took off in the 1960s with some Supreme Court decisions. So a lot of the case law that we're dealing with are Supreme Court decisions in the last 30, 40 years. And so there's a real clear body of law on what types of elements are involved with each type of claim. So it sets itself up very nicely in the jury instructions, and it provides a nice blueprint for what you have to argue and what kind of facts you have to develop in the case. I was asked yesterday to talk about, are there any resources? I'll point to 2 that I look at regularly. One is, it's a textbook called Cross-Examination, Science and Techniques, and it's by Larry Posner and Roger Dodd. I had the really good fortune when I started my career. They did an ICL training up near Gaylord. It was over the weekend at the golf course. These 2 authors spoke, and we were able to get that textbook. It's an amazing book. It was recommended to me by a Wayne County Council attorney. Very engaging. If you get a chance to see their presentation, do it. And but the book itself has it's a little misleading calling it cross-examination. It has an entire program dedicated to, how you prepare for trial, and it's more than just a cross-examination. So it kind of changed the way I prepare for cases. I don't utilize the program that they talk about 100% because it is so involved, but even doing a light version of it really shapes the way you look at stuff. It's an expensive book, so hopefully you can pick it up at a law library or take a look at it. The other one is the Prisoner Self-Help Litigation Manual by Daniel Manville. He's an attorney in Michigan. He's head of the Michigan State University Civil Rights Clinic, does a lot of these cases. In fact, we had a trial at the beginning of this month. He and I have gone against each other numerous times over the years, but he put together this book quite some time ago. It's on the 4th edition. I bought this copy on Amazon.com for like $40 when it came out a few years ago. A lot of your prisoner clients will already have a copy of it. It's a very popular book, so you could probably borrow their copy if you wanted to. It's got good footnotes on the different topics or the different types of prisoner litigation. It also has tips on, what kind of motions you're looking at and what kinds of evidence you need. So it's a good start to take a look. Our office has a 4-volume set of the rights of prisoners. It's by Mushlin. That also is a very detailed on the different, and you can find those in law libraries as well. So I love litigation. It's what I wanted to do. It's why I chose this profession as a second career. I think these types of cases are exactly the kind of cases that most people think of when they watch lawyers on TV. And it is very kind of exciting when you're going back and forth with a good attorney on the other side. There's a lot of dramatic fact patterns in these cases. They're not dull by any means. And they run the gamut from very minor issues that get blown up into a retaliation claim to very serious allegations of abuse and excessive force. But I will say my very first trial was in front of Judge Bell up in Marquette on toilet paper, and it was an 8th Amendment claim. And after 13 years of this, it's not the only toilet paper case I've done. So I like to tell people I may be Michigan's foremost expert on 8th Amendment toilet paper claims. They're kind of the Clarence Darrow, if you will, but I've also tried some very serious, inmate was stabbed by another inmate, and that gave rise to an 8th Amendment failure to protect claim, which is also one that shows up. And those cases can be very dramatic when you're showing a video to the jury of the actual stabbing taking place. And it's can get pretty emotional with some of the testimony. So I haven't regretted 1 minute of doing this, and I encourage you to do it, because I think just as we expect the public to do their duty as jurors and serve on jury duty, I think we as attorneys also have an obligation to represent the indigent, because it's what our country is kind of founded on, this idea that everybody has their day in court and they be as well represented as they can possibly be. And to address the time commitment, these trials really, I've done 4 in the last month, and I think every single trial that we've done this year has been a 2-day trial. So it's not a huge commitment. You can even ask up front, if they ask you to take a case, what kind of schedule are you looking at? Is it going to be a 1-week trial, or so there's some flexibility. There's a lot of cases, and in fact, most of them would only take a day or 2. So thank you.
Thanks, Michael. Sarah, I know you wanted to point out some other resources that are available even on the MDOC website, right? That help in a lot of these cases.
Yep. That's right, Amy. The Michigan Department of Corrections public out-facing website has a wealth of information on there. Like Mike said, a lot of these cases are alleged that a state employee may have violated policy, or something was involved with a policy violation. And as Judge Kent mentioned, the grievances are controlled by a policy. Pretty much almost anything an MDOC employee may do is controlled by an MDOC policy. And all the current ones are publicly available if they're not exempted for security reasons. So most of the time, as a pro bono attorney, you can get the policies directly from the public website, review them, and then if you, for example, in a case you did need an exempt policy, which are exempted for safety reasons, because let's not forget they're running active prisons, you can certainly coordinate with the defense counsel to get that subject to a protective order. There's also an MDOC website that's called the Offender Tracking Information System, or OTIS for short. That is a very quick way to find out where your client is in prison. It will give you the name of the facility, what security level he's in, and that's a very helpful thing to regularly visit, because prisoners do get moved, and my office is never notified when that happens. We'll have hearings scheduled the day they get moved. So we use it daily, and I recommend any pro bono attorney uses that as well. Amy, did you want me to go into how they could communicate with their client at the time, or wait till
Sure,
later?
I'm guessing people wonder about that, so
Sure.
that would be great to cover.
Yep. Most of the time, if you take on a pro bono case, the prisoner will still be confined with MDOC. Sometimes they do get out, and that's kind of a different set of circumstances. They're a free citizen on probation or parole. But if they're not, there's several different ways that you can communicate with your clients. Prior to COVID, most of the interactions occurred in person. Hopefully that comes back soon, but probably for the foreseeable few months, that's in-person visits aren't going to be happening. However, you can still mail them, like physically mail them documents, and that is not monitored. When it comes into a facility, it is not read by MDOC personnel because it's protected as legal mail. However, there's a JPay system, which is the prisoner's email system. If they are to email you through that system, that may be monitored, as that is not necessarily a designated protected system. You can arrange phone calls. Your clients can certainly call out to you, and they can make a disclaimer on the phone line that it's not supposed to be monitored. So there's multiple avenues that you can contact your prisoner, but physical actual mail is usually the easiest way in the current COVID times, because we're not even allowed to go into prisons right now as state employees because of many prisons are still dealing with COVID outbreaks. So hopefully after that public health emergency is resolved, in-person visits are resumed, and that's usually the easiest and most protected way to have conversations with your clients.
Andy,
Sarah,
oh, I'm
Amy,
sorry.
can I interject for a second? Sarah, I've had several hearings lately where we were able to get the inmate by Zoom. Is that an option?
Usually, Your Honor, that's just reserved for court appointments and manners like that, because as you can imagine, a prison is dealing with a lot. Typically, a male facility has almost anywhere from 2,000 to 3,000 prisoners. So there are rare occasions that can probably be coordinated, but they prefer that not be the regular course of business, because, for example, if we have a hearing with you, there's also parole board hearings that need to use the same technology. And it's a limited, a prison does not have an infinite amount of technology setups to allow prisoners just to use it on a regular basis. So that's typically reserved just for court hearings, but there are always circumstances that exceptions can be made, but that's preferred to be an exception rather than the rule.
Okay.
Andy, you have a case right now. How have you been communicating with your client?
Yeah, so my current case was appointed, I think it was February 2020, so just before, the world ended. And so unfortunately, we have never met him in person. It's always been over the phone, and we did have a settlement conference with Magistrate Judge Barron's over Zoom or whatever the equivalent was. But all our conversations have been over the phone with this particular client. With the other two that I did, we always met in person. One client was in Ionia, the other one was in Baraga, which is a long way away. And frankly, I strongly believe that meeting in person is far preferable, because one of the challenges in these cases is you have to get your client to trust you. They don't know you. They didn't really have any choice in selecting you. And, it takes some time to develop a rapport with the client. And in my view, that rapport can best be achieved really by sitting in the same room with them and talking with them for a significant amount of time.
LaRissa and Andy, I think it would be great to hear how you've each approached your cases from a preparation perspective, to give the attorneys who are in our membership and thinking about taking one of these on just a little bit better of a sense of how the case proceeds and what sort of commitment is involved. LaRissa, do you want to talk a little bit about yours, and then Andy, you can follow?
Sure. I guess, it will depend on what your current caseload is, obviously, but when I was appointed, when I was a brand new associate, so and I had the full support of my firm. And so they just made space for me to just dive in. Like Judge Kent says, the cases are pretty much trial ready. So discovery, discovery is already taken. You're gonna have deposition transcripts, motion filings. And so I just dove in and prepared from it's almost very much like law school. If you ever took like any type of trial, mock trial type proceedings, you have the fact pattern, the box of documents is already prepared for you, and you're just learning that set of facts. In rare circumstances, you may be able to go back in and do some fact development. But if you're used to that from the law school setting, it's modeled that way. If you have the support of your firm and taking on these cases, they're going to give you the time to do that. And so I just dove in and just, learn those depositions, learn the procedure of the cases through the motion, the motions and the orders that had been generated from those motions. But I took it very much like a mock trial type proceeding. So that makes sense.
And we should say to all the participants that LaRissa is the rock star of pro bono lawyers. She got a jury verdict in one of these cases. Total award was $200,000. Is that right, LaRissa?
Right.
Which is by far the world record in the Western District of Michigan. So maybe
LaRissa,
somebody listening right now can dethrone LaRissa.
That's the gauntlet. LaRissa, can you talk a little bit about why you felt, because I thought this was interesting, why you felt that those depositions done by your client were good as is for trial purposes?
Sure. When I got the depositions, and there was probably maybe 7 or 8 transcripts. My client wasn't educated. I think he had dropped out of school at like 15, he'd been in prison, so he wasn't educated. But he had really good instincts that I didn't appreciate at the time because I was a brand new, just fresh out of law school lawyer. But when I was reading through his, actually, let me back up. I had attended a presentation very similar to this with my shareholder mentor at my firm that I just joined. And we got back to the office, and Judge Carmody had left a voicemail on his machine saying, "Hey, do you and LaRissa want to take one of these cases?" So that shareholder mentor then calls me in his office and says, "Hey, I'm really tied up with this other case, but if you want some federal practice, here's the case for you. But I'm here to assist you." So I get this box of documents with maybe a handful of depositions in it, and I'm going through it, and I'm like, my own bias has kind of had me skeptical of what this case could be about and the veracity of it. But as I'm going through it, I'm like, wow, I think this guy has a case. And the depositions were very crude, but the facts were proving themselves just by the crudeness of them. So for example, one of the issues in my case was whether or not one of the key witnesses and my client, the inmate, had colluded in getting the story together so that they could retaliate against this guard. And the MDOC asked the question, the Attorney General's office asked the question in the deposition, "Hey, did the plaintiff ever write you any letters, talking about what you were going to say at this deposition or in trial?" And the deponent is so paranoid that MDOC is messing with his mail. He starts, there's like 4 pages of deposition transcripts where he's angry, like, "I didn't get any mail. Did they send me letters? If they got some letters, I'm grieving. I'm going to file a grievance because I didn't get anything from, plaintiff," which just corroborates that there was no collusion, So there were many gems in the depositions like that I made the strategic decision not to ask the court for any more discovery, because I thought the crudeness of in which the deposition the deposition was taken and the testimony was given added to the credibility. And I thought that if I went in and tried to just get some extra things or clean it up a little, it would just look like lawyering and maneuvering and manipulation, like smart lawyering. So and I don't know if that will be present in every case, but I remember walking away from looking at those documents thinking, wow, this guy's got a really good case. too bad that he's going to lose because he's got this lawyer who doesn't know what the heck she's doing, So I guess the moral of that story is once you can get past your own biases of who your client is, they have a wealth of information, a wealth of intelligence that might not look like the mainstream gauges of who is smart and who is not, and who is what is good information and what is not. But if you can get past all of that fluff and get just to the core, your client is your number one resource of what those really in your practice in general, but the same is true with these prison cases. And I leaned on my client. I leaned on Dan Manville's book, but I leaned on my client probably more.
Interesting.
Thanks, LaRissa. Andy, how have you approached these cases?
Yeah, so in 2 of the 3 cases that I've done, we have asked for discovery and the court has allowed it. And when we asked for discovery, it really was for 2 reasons. One, when we got to the case, discovery either hadn't been done or hadn't been done well. So we felt that we needed to do it to sort of, shore up our position. And also, quite frankly, for a younger associate, the opportunity to go take depositions is a valuable opportunity. So in each case I've worked on, we've had a younger associate and I've said, go depose the defendants. The very first one, we took our summer associates that summer and we sent them around the state to do witness interviews of prisoners. And they came back with some very interesting stories. So, it was a valuable experience. Unlike LaRissa, the first case that we tried, did not result in a $200,000 verdict. We got no caused in about 25 minutes. So not quite the same result.
Michael and Sarah, are there opportunities in these cases to do anything in the way of kind of informal exchange of information to cut down on the possibility of the more formal discovery that takes time?
I'll answer this one. Absolutely, there is an opportunity to do that. And I think that's one of the best skills that you can learn is, I like dealing with a professional on the other side. So, anytime someone's appointed, I appreciate that because it makes the process that much smoother. So, but like anything else, how you get off on the right foot with each other as opponents can make a lot of difference. So if I've got transcripts, I'm usually very happy to turn those over to speed that up. If there are documents that I know are relevant that we've already come up with, we will make arrangements with you informally to exchange that, especially if we're getting close to trial. I'm not going to try to hamstring anybody in terms of getting information. Now, there are some things that people request because their client asks them, hey, get the videotape. I will tell you in those kind of cases, some of these cases are 4, 5, 6 years old. At the time the lawsuit was brought, there's only a limited amount of time for some incidents to be recorded and the tapes tape over themselves. So unless it was part of something like a critical incident report where somebody got injured and they pull all that, if it's just an officer and a prisoner jawing at each other back and forth, there's usually no reason at the time for them to have collected that video. So that's the kind of things, if we have it, we're usually pretty open about getting it unless there's something that needs a protective order. I'm kind of like a mother hen. When people just ask for institutional or my personnel records of my people, we may have an argument back and forth because there's a lot of information in there that's not only not relevant, but could potentially be a threat to the officers if it was somehow accidentally disclosed personal information or identifying information. It is prison, and there are serious allegations sometimes where someone has a member of a gang gets in contact with somebody outside to try to threaten or harass officers. So it is a very touchy issue with the MDOC, and I understand their concern completely. I've done this long enough to know that there are some cases that end up, well, I'll tell you this, the trial I did a couple of weeks ago, the plaintiff was out of prison he lost, or the jury gave him $1. That was not what he was looking for. He confronted my client, who he just said goodbye to, and crossed the street to the parking garage and threatened my client. So we had to go through the process of letting the U.S. Marshals know. And it was in a parking garage that jurors often use to get to the courthouse. So had some of the jurors exited, and he's in a angry state of frame of mind. There's no telling if he would have confronted them either. So yeah, it is a serious issue on stuff like that.
And Amy, to further Mike's point, I forgot to mention, on MDOC's public outfacing website, if you have a case involving medical records, there is a whole page on how to request those records, things like that, and you get them from the MDOC directly. It's not something that your client's going to be carrying around with him. But to touch on what LaRissa said, these prisoners usually have a lot of records. They are allowed a lot of legal property. That's what MDOC calls it. So if they have been working on their case for years by the time you get it, and typically a case when someone is appointed has been around for anywhere from 3 to 5 to 8 more years, and it's been around for a long time. So definitely ask your clients what records they have, because they get copies of their grievances, things like that. And certainly when a new counsel is appointed, my office and my attorneys will provide you copies of any discovery that's already been produced. I would say in more cases than not, we have a lot of prisoners that send voluminous discovery requests, and we respond to those and fight about who can have what. Because like, as Mike said, these guys are in prison, and there's no guarantees that if we gave something to them, it's going to stay with them. So there's a lot of additional considerations. So when you hear my attorney start talking to the appointed counsel about, hey, we have concerns about releasing this, and here is why. We're not trying to be obstructive. We as state employees have an obligation to protect the other state employees that work in those prisons, because they do a job that most people don't want to do. And so we have to protect them from any future actions, because let's be frank, we all don't think like criminals. And I'm not saying your client is going to try to do something bad, but you don't know who he's rooming with. We don't know who he's rooming with and what their intentions are. So there's a lot of limitations on documents that we can give out. And I know Judge Kent is very familiar with discussions back and forth between the parties on what an appropriate protective order is and things like that. We're not trying to be obstructive. We just have a job to do, just like the appointed counsel does, to try to figure out the information. But there is a lot of sources outside of the formal discovery process that if you are professional and cordial and ask us for, we will certainly cooperate. Because as Mike said, the bar community is a small community, whether we're on the defense side or the plaintiff side, and we all have a goal, and that's to do justice, whatever justice may be in the instant case.
And at the end of the day, that's what the courts are for. I mean, those are the types of things that you have to ask once you, those are the types of discovery that I'm sure, even though generally there's not a lot of discovery that happens when you get these cases, but if there's a key piece of document that you felt fit within the discovery request and it wasn't given to you, I mean, you know, you make those calls the same way you would in any civil case. You've got the same standard of what's, you know, protective orders and how to protect the rights of the people involved. So,
Michael, you mentioned earlier, oh, I'm sorry, I didn't want to break up.
No, I was just going to say, as a side note, we generally want the videos as much as your client does. From our perspective, whether it shows our guy was in the clear or not, if he's not in the clear, we would rather know that up front as soon as possible if we need to discuss settlement. So I love having video, and it's not always been in my favor either. So definitely our office is not doing anything to try to hide anything or keep it out there, out of view. It's worth it to have it if it exists. So, and I'm sorry I interrupted you.
Well, you mentioned one thing, I'll try to return to that comment, but you mentioned the opportunity to settle these cases. Could you talk a little bit about whether that opportunity will arise in these cases once they're assigned to the pro bono attorney? And if you wouldn't mind also talking about what other settlement discussions may have happened before that, just to give the group a sense for how trial ready this case is.
Okay. We've just created recently in the last few years a kind of at the outset of these cases being filed an early mediation program where someone from our office discusses with the prisoner to see if there's a way to settle it at the outset. So the cases that you'll be seeing coming forward are generally have already gone through that process. Towards the end, after a court-appointed attorney, there's usually a settlement conference scheduled with a magistrate judge before trial. And there, Judge Kent can probably speak to this as well. The MDOC has a strong policy that they're not going to settle cases generally for the nuisance value of it. Retaliation cases are extremely hard to get dismissed on summary judgment. So almost from the outset, we're approaching retaliation cases as ones that we think are going to end up going to trial if we don't find a way to get them dismissed on summary judgment. If the department settled every single case like that, it provides a perverse incentive for prisoners who are generally would view $1,000 settlement much more favorably than the general public would. It would create a perverse incentive for them to keep filing more lawsuits in order to get to the settlement phase. So most of these cases, unless they involve a significant physical injury, the department's not going to authorize a lot to settle cases. The last 4 trials that I did from February until this month, we had $500 in authority for each one of those cases. The plaintiffs were asking anywhere from $12,000 to $150,000. So clearly we didn't settle. In 3 of the 4 cases, they got a no cause. And last week we had a judgment for $1. So that kind of tells the MDOC, look, they're gonna keep offering that amount for these cases that are generally minor retaliation type cases, because juries generally will find in favor of the government. So, and
That's helpful too, because I think, you know, Andy and LaRissa, without getting into the communications you had or have with your clients, you know, how do you set expectations for the inmate about what this case might look like at the end of the day?
And what I would say, just adding on to that, that's a perfect, your biggest job will be managing your client's expectations in terms of settlement. And I think anyone from our office would be happy to tell you or have a discussion with you the types of cases that we've settled for more than that. I've definitely settled cases for $5,000 to $50,000 to over $100,000. So we do settle cases, but they have to fit a certain parameter. So
I found that I think when the complaint that my client filed on his behalf, he asked for something like $1 million. But I found that, you know, in having a discussion with him, his expectations were more realistic than even my own, you know, being a fresh, you know, new lawyer ready to right every wrong of society. So, I mean, they're the ones living in prison, so they have a pretty realistic expectation about chances of success. I found that, you know, his dollar value was just, you know, a bit, you know, just wanting to put a large number on there because of something that he felt was so egregious, you know, the act that was so egregious against him. So talking him down from that number was very easy, you know, from my perspective. You know, our approach was that we took that $1 million number and just asked the jury that if you find what my client says happened, in fact, happened, you know, we're going to leave it to you to put a fair number on that. My client's asked for $1 million. You know, he probably is not going to be $1 million, but whatever you think is fair. So, but as far as expectations of success, I think they come from a more realistic vantage point than even, you know, we do as their advocates. It's way different. I have a more difficult time client control with in civil cases, my clients who are not inmates, you know, so they're more idealistic, so.
I think the inmates, I mean, it's many, I'm sorry, Andy, let me just make a brief point and then you're up. The inmates, many of them have been through the process more than once. So a lot of the inmates have filed 1, 2 or 3 or 4 or 14 prior lawsuits. So they've been through the process. So they have their own experiences about what the likely outcome is going to be. And of course, they talk to their fellow inmates about their experiences going through the process, filing lawsuits, how those lawsuits turned out. So the inmates are very educated about the process and about, I think, what the outcomes are likely to be. Andy.
Yeah, I think at the outset, in my experience, a lot of times the expectations are not realistic. And that's part of, the trick of, the task of trying to build that rapport with the client and develop the trust with the client so you can advise them and, hopefully, bring them into a realm where you can make some progress on settlement. I think a lot of times in my experience, they hear about the outlier case, the LaRissa's case, and they think, well, that's my case. If that person can do it, I can do it. And, it takes some time to sort of work through those issues and maybe explain, maybe this isn't quite the same. This isn't quite the same situation as some of the other cases that you heard about. We were able to, of the 3 cases that I worked on, we were able to settle one of them. We tried one, we settled one, and we got one ongoing right now. So, we have had some success in getting settlements.
One more logistical question that I was just thinking about from my own experience mediating one of these cases recently. How difficult is it if the prison inmate has another prisoner who he wants to call as a witness? What are the logistics surrounding that? Is it possible? Is it hard to get them into court to testify? What do you find?
Sure, I can address that, Amy. It's really dependent on when the case goes to trial. For example, right now in the last several cases we've had due to COVID, they have testified remotely, essentially via Zoom. The prisoner, and obviously through counsel, you have to subpoena and request a writ of habeas corpus for the prisoner to either appear remotely or in person. Pre-COVID, we'd usually have a couple prisoner witnesses writted out in person, but that has cut back due to COVID and the amount of personnel involved in transporting a prisoner. It's pretty significant for the MDOC side. So we always try to work to see if there's an option to have them testify remotely.
I had, I believe, 4 witnesses, all of them were inmates. And I didn't have any, I think we read one deposition into the record, and the rest appeared live, and we didn't have any issues at all.
Hey, Amy, can I make my couple final comments?
Please do. We're at that time.
Okay. So for those of you, who are thinking about getting involved in this program, as I said before, you're doing a great service to the indigent in our community. And that is a hugely important undertaking. And, if you don't believe me, Chief Justice McCormick authored an article in a recent Michigan Bar Journal from February of this year. It had to do with plain language, but it was one of her interests and focuses is access to justice and how it's the basis of our government. It's the basis of our society. So when you help folks feel that they are not disenfranchised just because they're poor, you're doing a huge service, to our country. Second, you are probably going to get to try a jury trial in federal court. And I'm going to pick on Andy because he's with a big and outstanding law firm here in Grand Rapids. But if you young second or third year lawyer out there listening, take one of these cases and get a jury trial, you will have one more federal court jury trial than most of the lawyers in Andy's law firm. So
True.
it is a hugely valuable part of your learning experience. If you want to be a trial lawyer, and I know Michael shared with us in a meeting recently that he went to law school because he watched the movie A Few Good Men and thought, you know what? I want to do that. So, but to do that, you got to get into court and do trial work. And so this is a chance, it's a way for you to get into court and have a jury trial in front possibly of an Article 3 judge or a magistrate judge. We all do them at a point in your career where that opportunity is not available to most of your colleagues with your same level of experience. So I don't know. It seems like a win-win to me. It's good for you. It's good for an indigent inmate. It's good for the community, and it's good for the country. So, rah, rah. I hope you all sign up. I've got cases for all of you.
Thank you, Judge. And I do
welcome.
want to just harp on that. This is a year in which Hillman had to be postponed, as many of the lawyers in our community know, due to the pandemic. And so I think this may be the best opportunity to get something kind of like a Hillman experience, because you will get a case that's trial ready or close to trial ready, and you can take it to Judge Kent or Judge Neff or whichever judge is hearing the case in front of a federal jury. It's an awesome opportunity. We do have one open question in the Q&A. Is there any data published on jury verdicts for the cases that might help us to manage client expectations? Sarah and Mike, are there any, or Andy and LaRissa, if you know of any?
I think through Lexus, but I don't think our office has that service to do it. For us, it's just as easy for us to go down the hallway, and I mean, we all talk to each other about what cases we've lost. So you can ask the AG on the other side what kind of cases, and I'll even give you case names of my own and some of the others that are pretty famous in our office for big jury awards. So I'm certainly not going to keep that information from anybody. So.
Yep, and that was my experience in an early mediation case that I just asked the AG to provide some example jury verdicts and showed them to the prison inmate, and it was helpful. Let's see, Tessa is asking, oh, could you give a general range of the average verdicts for these cases? She's also doing the early mediation program, and
all right.
You're always certain they can get a better offer than what is being offered.
Yeah. Is this settlement or verdict, jury verdicts?
I think she's asking about jury verdicts, but for the purpose of doing the mediation.
Oh, Mike, go ahead.
I was going to say, I just did my 55th trial last week in 13 years. I've lost one trial for $66,000, one in front of Judge Kent for $5,500. I had one for $900 verdict, two $250 verdicts, and two $1 verdicts. So that's.
Hey, Mike, in how many of those cases was the plaintiff represented by a lawyer?
I've only lost to one attorney, and there was two different cases, the $66,000 one and the $700 case. Every other trial I've lost has been to a pro se plaintiff.
Yeah. What percentage of the cases, though, was there a lawyer?
It used to be in the Eastern District, I could almost always expect to have pro bono attorney, but we also try probably 2 times as many cases in the Western District as we do Eastern District. Back when I started, maybe 1 in 4 would have a pro bono attorney. Now I'd say it's at least 50-50. And in fact, out of the last 4 trials, 3 of them had attorneys. Only one of them was pro se.
So even if it's 50-50, folks, that again highlights the fact that, you know, we need you. And these inmates need you. They need help. They need your help. With the exception of Mr. Dykes, most of them That's a little stab at Mike. With the exception of Mr. Dykes, who was an inmate who tried his case by himself and got a verdict, a modest verdict, but a verdict. They're going to do way better with you representing them than they are representing themselves.
On that note, I think it's time for us to adjourn. Thanks everyone for participating. We look forward to working with you on these cases, and I will be shooting an email to everyone who joined us to see if they're willing to take on a case.
All right, so I expect what, 29 names on that list? Is that what you told me, Amy? Okay.
And thank you to our panelists once again for joining us and for sharing your stories.
Thank you all.
Thank you, everybody. Thanks.